Right. Okay, we will make a start, but just to remind everyone, the session is being recorded, so and a copy of the slides and the recording will come out to everybody. So if you want to go, you join late and you want to come back to it, you can do, and there'll be a recording for you to listen to. So good morning, everyone. My name's Nicola Dawn. One of the partners in the insurance department at Forbes Solicitors. And I specialise in claims for occupational diseases. For those who haven't met me before, working for a number of insurers and local authorities and corporates themselves as well. Um, and co-hosting this webinar with me will be Jim Hester, who's a barrister at Park Lane Plowden Chambers, who I've worked with for many years, who also shares an interest in this area. And what we want to talk to you about today, when I was invited to pick a topic for my webinar in the series, was about silicosis, as it is pretty much a hot topic in the news at the moment, particularly as the fashion for kitchen worktops made of particular materials leads to them maybe having an element of silica dust, which if people aren't protected properly when they're cutting it, can lead to silicosis. And we're seeing that the trend that claims are increasing for this area. So lovely Hannah from marketing is on the slides today. So if you can move to the next slide, please, Hannah. So what we're going to cover with you today is we're going to take you through breach of duty, causation, what to look at quantum wise. And then Jim's going to wrap up with this section about advice and what kind of documentation we should be advising our insureds to keep, or what we should be having a look at what we've got available when we're looking at whether we can defend a claim. So I will hand over to Jim without further ado to give you a bit more of an introduction and a rundown on the breach of duty side of things.
Good morning, everyone. Thank you, Nicola, for that introduction. I think the reason for giving the talk today reminds me of not very long ago, I was in court and an expert, in fact, my expert was saying why he enjoyed being a medical expert in cases. And he said there were two reasons. First of all, he found it liked to help people. And the second element was he found it interesting. And I think today, hopefully, that those are the reasons why we're giving this talk today, is that we like to pass on the knowledge to those who might be appreciative of it, but also we find it quite interesting ourselves. We like talking about it and discussing it, and welcome for any comments at the end of it. So hopefully you will benefit from it in the same way that we will. Starting off with breach of duty, of course, breach of duty is the starting point for any claim. For silicosis. Silicosis is almost certainly going to apply in the employer-employee relationship, and obviously there's a long-standing Wilson's, Clyde-Cole, etc. in relation to there's a breach. There is a duty of care there. Clearly, there's some cases where whether someone's an employee might be up for the debate, and that's a slightly different issue. But it's likely to be the employer-employee relationship in which we're looking at, and in such circumstances, I always start personal injury claims, and I practice exclusively in personal injury, and as Nicola said, very heavily in industrial and occupational disease cases. Starting off with the premise of, is there something which wasn't done that ought to have been done? Or alternatively, was there something that was done that ought not to have been done? So that is the way that I tend to approach personal injury claims, and just to see what the answer to that is. And usually individuals on either side will be able to say that in layman's terms, what it is they are actually complaining about and whether that has happened or not. I wonder if we have the next slide, please. So in short, in silicosis, it's relatively straightforward. Actually, what the breach of duty will be, is exposing someone to a level of silica which can cause someone injury. And that's it, really. It's nothing more complicated than that. There are lots of things that go behind that, and there are lots of things which may be considered. But in short, that is the answer where we get to, has someone been exposed to excessive levels of silica, in which a claim for silicosis might be made out. Next slide, please. Thank you. Now, in relation to silica and the dangers of silica, it is in many occupational disease cases, there is what's called a date of guilty knowledge, the point at which defendants' employers ought to have known better, essentially. So, for example, if we're thinking of In a noise-induced hearing loss case, you might look at 1963, and you might think about the Noise in the Worker publication in relation to Hav's various publications by HSE, hand-arm vibration syndrome, in relation to asbestos, various incremental knowledge over the years, and at different stage the knowledge has changed. It's less so in silica claims, because they have the injury caused by silica has been known about for literally millennia. So looking at it there, Hippocrates sets it out 460 to 370 BC. Breathlessness in persons exposed to dust in mines and stone quarries. Silicotuberculosis, which is a potential silica can increase the risk of tuberculosis. Silicotic nodules observed in the lungs of some Egyptian mummies, quarry mining and stone masonry, a common occupation of the era. Indeed, a glacial mummy from the Austrian-Italian border, living some 3,350 or so BC. And if anyone is interested in the history of silica, that article which I referenced at the bottom is an open source one. It's relatively short and quite interesting in actual fact, how we have got to the situation where we are, and the long-standing nature of the illnesses caused by silica. It's generally considered to be the earliest occupational disease. So next slide, please. More recently, however, it's been known about in this country during the Industrial Revolution and onwards. Dr. Calvert Holland, a hospital physician in Sheffield, describes local cutlery workers exposed to the silica. So they were grinding, as it's set out there, grinding forks or cutlery, and it was the grinding stones themselves which are causing the silica. He describes that there is more disruptive to human life than any pursuit in the United Empire, and there was some probably fairly strong competition in that era. It says, of those who were shaping forks, half died before the age of 30 and none survived the age of 50. Of course, in its most extreme form, silicosis can cause death. It was known as grinder's asthma, but of course that's not quite the way it was. Now, the reason why Dr. Barber, who was the occupational health physician who wrote the article I referenced there at the bottom in the Thorax magazine. Thorax magazine is the magazine for respiratory physicians. And I should declare that Mrs. Hester is a respiratory physician, so I tend to get past articles of occupational health interest that she comes across through that magazine. And Dr. Barber is in fact someone who practices in Sheffield, and the point he is making in that article, which was an editorial from October 2024, is that in actual fact there's a relatively recurrent history in the modern day. People who are suffering from silicosis, both in Australia, USA, and UK, it tends to be those who are struggling with poverty, illiteracy, and often, particularly historically, had to continue in the trade despite knowing the risks, despite knowing the number of people who historically, back in the 1840s, were dying of the condition. And it's very much the same seen these days, in that those who are most affected are often migrant workers in the three Western countries that are set out there. Often people who've got limited English, don't understand the health risks, or indeed the fact that health and safety is really a thing. They have limited access to healthcare, possibly more so in this country than in others, and limited socio-economic options. Essentially, they often have to do it. And perhaps just as an aside, the processing of artificial stone for worktops is something now which has been banned in Australia. There was talk of it happening in parts of America, but I don't think it ever actually did happen. But it is essentially what was happening in the 1840s is something that is still continuing to this day. So next slide, please. So silicon dioxide I understand it's the most abundant atoms in the Earth crust, silica and oxygen. It is the crystalline silica, which of itself is actually resistant to being broken into respirable particles. So by itself, naturally, it would not be cause something which is a problem. It is force required to create what is set out, and is the dangerous dust which is caused, the respirable crystalline silica RCS, and that is the fine dust which can enter the lungs and which can cause the silicosis, of which obviously people suffer from. Next slide, please. As you'd expect, if force is required, the greater the force, the greater the RCS from any given material. Nicola will touch on some of the materials which silica can be come from. It can be sand, stones, rocks, any material containing silica, and it is the movement of it, the crushing, the milling, processing, drilling, grinding, polishing, cutting, or collision of it. And as Nicholas touched on there, the artificial stone silicosis is something which is particularly of interest recently. The bans in Australia, I think California was a place that was considering it, although I don't think in actual fact did ban it, although further measures were taken. But the same point about the artificial stone now is as for the grindstones back in 1840s Sheffield and the cutlery industry, is that it's hard wearing and it's durable. And so the reasons why it was chosen then was the same reasons it was chosen back in Sheffield in the day. But of course, the higher the levels of silica, the worse the exposure. And it will come as no surprise that the greater the injury will come from two factors: the amount of exposure on any given day and the duration of that, whether it happened for a very short period of time, it's very unlikely to cause any damage. If you are talking low levels of exposure, it might take very many years to cause a problem. At the highest levels, it can happen in a matter of months. So it is a combination of the factors which comes to cause the problems for people. Next slide, please. So in UK, there is a workplace exposure limit. It is something which can only be calculated with specialist assistance. 0.1 milligrams per meter cubed of respirable dust in the atmosphere, averaged over an 8-hour working day. However, this is not something which will actually prevent silicosis, although it will reduce it, the chances of it, by reducing the levels to that level. And indeed, the most recent, or the second most recent, Thorax magazine, again, one of the has been passed to me, sets out that in actual fact, perhaps there's an argument for that level to be reduced in half, essentially, to the 0.05 milligrams per meter cubed. So it is it's a level, if exposure is reduced to 0.1, first of all, the risk is being reduced very much so. And so the chances of someone contracting silicosis are greatly reduced. Likewise, it is going to be more difficult to argue that if the exposure was, for example, at 0.08 milligrams per meter cubed, that there was any breach of duty in those circumstances. So it is certainly something to consider. As in all areas of exposure to anything, the lowest reasonably practicable level is the ideal level. So essentially, if you can reduce it to zero, even better. Next slide, please. So the legislation we're likely to be looking at and considering it is against the Control of Substances Hazardous to Health regulations. RCS is clearly a substance which is hazardous to health. It clearly causes silicosis and indeed other conditions, and therefore a number of measures ought to be taken. Next slide, please. And they are set out there. And I'm going to go into how to action these in more detail in a later part of the talk. But in terms of the things that would be expected to be seen, is that there should be a risk assessment, and we'll come on to how important a risk assessment is, because without a risk assessment, clearly, no one knows the risks or the measures that can be taken and should be taken. As set out in Regulation 7, the ideal is to prevent exposure completely. Now that might be by replacing a material using silica with something else. And that would be the ideal, simply so that the problem does not occur. Again, that would be the same in any kind of exposure. Can you, in actual fact, just remove the exposure entirely? If not, then there adequate controls need to be put into place, and things that are talked about. I talk about work processes, systems, engineering controls, ventilation systems, personal protective equipment, trying to reduce the number of employees who are exposed to it, and trying to reduce the level and the duration of any exposure. As set out in Regulation 8, clearly these need to be enforced. So it's not just a question of having something set out on a piece of paper, which is very of itself would be perfect if implemented. There is the necessity to implement it and make sure it is implemented. Any measures which are mechanical need to be maintained, examined and tested to make sure they continue to work. There needs to be clearly a monitoring of exposure and health surveillance as necessary. And the key thing for anyone who's working with these kind of products is information, instruction and training, so that they know what they ought to be doing, any measures they ought to be taking, and so they know how to reduce their own exposure. So I'll set those out in a bit more detail towards the end of the talk, just how we practically those translate into practical measures for people to enact. Now back over to Nicola for causation.
Thanks very much, Jim. That was really interesting. So obviously with causation, what we're looking for is that the claimant has to prove a direct link between their alleged occupational exposure to silica dust and then their subsequent diagnosis of silicosis. And they have to provide clear medical evidence that the inhaled silica dust caused the disease. Next slide, please, Hannah. So what is silicosis when we talk about silicosis? Now, silicosis is a type of fibrosis, so it's very similar to when we're looking at a claim for asbestosis. Would you say, Jim, there's quite a lot of similarities in terms of how it presents? So what silicosis is a progressive and irreversible lung disease that leads to the lung scarring, which is what we talk about when we talk about fibrosis. And that lung scarring then restricts the ability of the lung to breathe properly, and this is why you get breathlessness and loss of lung function. Unfortunately, there's no cure once the condition develops. The treatment will very much focus on relieving the symptoms and trying to improve the quality of life for somebody, and ultimately trying to slow the progression of the disease, because it's quite a quick moving. It's not like asbestosis in that sense, which is quite slow to progress. It can progress quite quickly depending on the amount of silica that you've inhaled. So a lot of people will have a key management strategy in place by their treating clinician, including there'd be a definite plan not to have any further exposure to silica if possible. They'd normally be advised to stop smoking. If they do so, there are certain vaccinations you can have that will reduce the ability of the silicosis to develop quickly. And there'll be some pulmonary rehabilitation programs. Ultimately, if it becomes quite severe, then a patient may need to have oxygen therapy as required. And in some severe cases, it can actually get that bad that it needs to be a level that a lung transplant is required. But thankfully, that is fairly rare. Next slide, please, Hannah. As Jim says, the cause of silicosis is basically inhaling large amounts of this crystalline silica dust. Usually someone will inhale it over many years. And traditionally, where I found that I was dealing with the most silicosis claims was claims for people who worked in quarries traditionally. But obviously now, as the publicity suggests, we're having people who work fitting the fashionable kitchen worktops that are made of certain types of quartz that contain silica. And as Jim alluded to, Some of the people who are fitting these are immigrant workers who may not have the best handle on English, may be having to do this type of work for socioeconomic reasons. And therefore, we've got to look at whether proper PPE was provided, instruction and training. Silica is found in certain types of stone, rock, sand and clay. And working with these materials can create a very fine dust that's easily inhaled. So if you're cutting it to get a worktop to fit a kitchen, that's when the cutting, particularly when the dust goes into the face, that's where it can really start to impact on being exposed to it. And once that dust gets inside the lungs, it then causes the swelling and inflammation, which then gradually leads to the areas of hardened and scarred lung tissue, which is what we call when we talk about fibrosis. And the main symptoms are very much, as I say, kind of like you would see in an asbestosis claim, that there's a persistent cough, there's persistent shortness of breath, and that combination can lead to weakness and tiredness, particularly if there's a lack of sleep. And also if you're getting very much out of breath on walking very short distances, even on the flat surface. Can I have the next slide, please, Hannah? So, as I say, traditionally, I've mainly seen these sorts of claims in stone masonry and stone cutting claims, also in some construction and demolition. But now we're seeing it become much more to the fore in worktop manufacturing and fitting. And it's as the fashion dictates at the moment for the type of kitchens that people want. So we're starting to see that a lot more. But we had also had it, you can have it in pottery, ceramics and glass manufacturing, sandblasting. Also anyone sandblasting may be blasting elements of silica as well. Can we have this next slide, please, Hannah? Silicosis is a funny one because it's got a latency period, as you would see with the asbestos related conditions. And if you've got a particularly high level of exposure, it can occur after a few months. It's not a case of it may take years to develop. If it's really high exposure, it can come on fairly quickly. If you have a moderate level of exposure, it can develop after 5 to 10 years of exposure. But in most cases, you'll see it takes around 10 to 20 years before you'll see symptoms develop. And again, that's because it's got to get to this process of there being enough silica inside the lung that it causes the scarring, which then inhibits the lung from operating properly and causes breathlessness. Next slide, please, Hannah. Also, when your lung starts to become compromised, that can then lead to other conditions starting to develop, and because of the inhalation of the dust. So, as you would expect with a lot of the respiratory disease claims, people are susceptible to chest infections. They also might be susceptible to pulmonary hypertension, heart failure, arthritis, kidney disease, COPD, particularly there's a mixture of a smoking history in there as well, and also lung cancer, unfortunately. Next slide, please, Hannah. But of course, there are other causes. So there may be, you've got to look at whether there is a viable different diagnosis, because fibrosis can be caused by asbestos exposure, as we've talked about, and is asbestosis. There might be a family history of fibrosis. Some medications are known to cause it. Radiation therapy as well. So it's important to look if the claimant's had any cancer treatment in the past. There's viral conditions, and there's also autoimmune conditions such as rheumatoid arthritis. All of these factors can cause a type of fibrosis. And it may be that in many cases, treating clinicians don't know what the specific cause of the fibrosis is. So that leads to a diagnosis of what's a kind of a purely constitutional diagnosis of idiopathic pulmonary fibrosis, which is IPF. And for those dealing with asbestosis claims, you'll see that if there's a rapid deterioration in symptoms, we would normally plead in a defence that it should be IPF rather than asbestosis, which might develop quite slowly. So it's important to look at, is there anything else that could be leading to this condition, or are we satisfied that the particular claimant has been exposed to quite a great deal of silica dust when working with the entity that we're having in mind to. Next slide, please, Hannah. Now, the test is with this, the test for causation is the but-for test. So, but for the would the claimant silicosis have occurred but for the defendant's breach of duty? So without us exposing him to lots of silica, would they have obtained silicosis or would they have a type of fibrosis anyway? So that's very important to look at, and that's the test with this one. Next slide, please, Hannah. So I'll hand over to Jim. So if you're satisfied that breach of duty and causation are met, then obviously we'll turn to look at quantum, and Jim's going to look at the general damages side of that now.
Thanks, Nicola. Just considering there, you were talking about the lung fibrosis. I think some of you may have heard of the general term pneumoconiosis, which is a generalized term to describe lung fibrosis from inhalation of dusts. Historically, it could be coal workers' pneumoconiosis, silica and asbestos. And it's my understanding of the condition, as Nicola set out, is essentially it causes a scarring. It causes the area of the air exchange no longer to work in the areas that are affected. So the exchange of gases from carbon dioxide to oxygen no longer works in the areas affected, and therefore that is what causes people to have the shortness of breath, because essentially the lungs are no longer functioning in the way they're doing. They're not as elastic as they used to be and as they're designed to be. So that moves straight on to really quantum. And I'm going to be fairly quickly in relation to pain, suffering, and loss of immunity. Pain, suffering, and loss of immunity is obviously the damages relating to the injury itself, and it's fair to say, considering each of those, pain, suffering, and loss of immunity, for respiratory conditions causes whether you can breathe properly or not. It's quite high up on the scale. Clearly, if you are having problems breathing, it's something you do non-stop, and on any exertion, you are using your respiratory function and your respiratory system. So it's clearly a significant problem. Next slide, please, Hannah. I'm not going to go through each of these. They are set out in the Judicial College guidelines. Each respiratory condition, essentially, although the cause may be different, the guidelines try to make them comparable in terms of how much they should be. And you can see at the top end there where there is someone with a serious disability who's young, and it may lead to death, and it can do in the worst cases of silicosis. You can have awards in excess of £100,000. What you'll sometimes see and often see is that the respiratory disability scale, originally set out for COPD, is often used as a form of assessing how bad someone's problems can be. So over on to the next slide, please, Hannah. Likewise, it is a sliding scale. The top one deals with lung cancer, which of course may be a potential problem in the future, even if not at the time. We then have essentially a sliding scale depending on how bad it is, and it's likely some comparison will be used, although I've not set them out, in relation to the general respiratory problems, which is set out more clearly in the asbestos guidelines. And next slide, please, Hannah. And we get on to the lowest level. It's unlikely that, as Nicola said, silicosis is a one-way condition. It does not get better. So someone's not going to have it for a bit and then get better from it. Indeed, at the early stages, it may be visible on scans and imaging without causing any symptoms at all, which is one of the difficulties of it. It only tends to appear once it's fairly developed. And as Nicola set out, it can, in fact, I think in the vast majority of cases, will continue to progress once, even after exposure has ceased, because the condition, because this lag condition continues to get worse even once exposure's finished. So it's unlikely to be at the lower end of the scales there. Next slide, please. Thank you.
Right, so once we've looked at general damages, we have to look if there's any special damages. So I'm just going to take you through some of the features that you could see in a silicosis claim. Next slide, please, Hannah. So if it's somebody who's living, who's currently suffering with silicosis and is bringing a claim, you would expect to see a lot of the kind of heads of loss that you would expect to see if you're used to dealing with asbestosis claims. So there will very often be claim for travel to and from doctor's appointments and also car parking. Very often those aren't evidence with receipts. There'll be a nominal amount claimed, and as long as that's sensible, that's something we probably would agree. They also might claim for any medical expenses, such as prescriptions. Some people suffering from silicosis might be on steroid treatment, something like that. And unless they are exempt from the prescription fee, you may well see a claim being presented for that. They also might claim for things for aids, such as if they've had to have a stair lift fitted into their home because they can no longer climb the stairs, a wet room if they can't get upstairs to the bathroom, or a commode or something like that. They also might claim for if they need to buy extra clothes, either because they've lost weight because of their condition, or if they because they feel the cold more in the winter. They might claim that they need extra clothes, extra bedding, things like that. They are very usual things for us to see under that particular head of loss. There's also an element that there may be some care required depending on how bad the respiratory disability is. So if you're looking at 10 to 20% respiratory disability, then you wouldn't expect to see a care claim, because actually what's happening there is just losing a little bit of exercise function there and can't walk as far as they used to. But if you're starting to get upwards of 40% respiratory disability on that COPD scale, then it may get to the kind of time when they might not be able to cope with personal care, or they may need help showering or something like that. And you would then, if it was somebody living on their own, you'd probably see professional carers coming in, or if they were living with a partner or family, or a friend, it may be that it's gratuitous care that we need to look at, and that is probably a whole webinar on its own, looking at care claims, which if anyone has any appetite for, I'm very happy to do in the future. But just to have in mind that that may be something to look at in this claim. There also might be loss of services. So if they can no longer wash their car, do the gardening, do the cleaning because they're becoming out of breath and they have to employ someone to do that, you may well see a claim for that. Now, something to look at when you're relating to this, we quite often get high multiplicans in these cases. So they will present that a claimant may have, be doing services that amount to £3,000 a year, something like that. And you've got to look at realistically what someone of their age and ability would be able to do, to consider that. And again, the quantum is a whole other topic on its own, so I'm just going to briefly go through this. The other thing that you might look at, particularly as we're seeing younger claimants coming through with silicosis, is loss of earnings. Have they lost the ability to work because of this? And if you've got somebody in their 30s and 40s, that can be particularly high, particularly if they can't work again. So we may need to look at actuary evidence for that, evidence from an actuary. We may need to get our own medical evidence in relation to that, something along those lines. Next slide, please, Hannah. So if you have a fatal claim, where unfortunately somebody's died of silicosis and the executors are bringing a claim on the behalf of the estate, we're looking at heads of loss under the Fatal Accidents Act. So there will be the funeral expenses, which will usually be evidenced by an invoice. Something that, sorry, just missing from there is also a statutory bereavement award, which is payable to a spouse of somebody who has lost somebody. And that's a prescribed amount that's kind of gone up in time as depending on the date of death. There may be a financial dependency claim. So if somebody dies well before their time, you'll see in the medical experts report that there'll be an estimation of their life expectancy, and the calculations will be done as to whether the dependent has unfortunately experienced a loss in financial circumstances, and we'll calculate that. Similarly, with the services dependency, if the deceased had provided a service that the claimant in the case can't provide, so it might be something like DIY, walking the dog, cleaning cars, anything like that, you may see a services dependency claim. And again, it's important to factor in that as traditionally, when we've seen older people claiming, how often they would, how long they would realistically been able to do that for. But if you've got a claim, it's suddenly got somebody who was deceased in their 30s or 40s, that's going to be a really high claim. Then, as in the asbestos cases, you'll see there's normally a head of loss claimed for loss of intangible benefits. So this is the loss of love and affection from a husband or wife. Arguably, that's covered within the statutory bereavement award, but there is case law that has awarded it. And again, if you're going to look with the sympathy of the court, if you've got a fairly young person who's passed away in a case, it is more likely than not that there is something going to be awarded under that head of loss, particularly because of the sympathy element of it. Next slide, please, Hannah. So that's kind of a very brief whistle-stop tour of quantum in these cases. But as I say, if anyone wants any further help on that, please do get in touch. And I'll hand over to Jim to have a look at advice and documentation.
Thanks, Nicola. And just following on from that, I think it's fair to say, and as Nicola was saying, is that both in terms of PSLA, that is for the injury itself, and also everything else, the younger the person is, if someone is starting to not be able to work, someone's going to require a lot of care over a long period of time, of course, those claims are worth a lot more than people who develop it later on in their life. So, as Nicholas touched on, it can be quite expensive if they're quite young people when they develop their problems. So looking at the advice and documentation, really we're just looking at how do we comply with the regulations. As you all know, strictly the regulations aren't actionable since 2013, but they are a handrail essentially as to where what an employer should do, and of course they are still in force in what an employer should do in any event in relation to that. So the regulations are really still of considerable use. Next slide, please, Hannah. Quite a lot of text on that slide, I realised when I put it up. Essentially, the risk assessment is a case called Kennedy Cordia Services. In fact, a Scottish case, but a case which is dealt with in the Supreme Court. And essentially, all it's saying is, in some statute, including the cost regulations, a risk assessment is required. But in any event, it is now accepted that a risk assessment is something that a reasonably prudent employer, which is the test the court will set out, will conduct in order that it can take suitable precautions to avoid injury to its employees. Essentially, if you don't think about what the problem is, you don't assess what the problem is, you're unlikely to get to the correct solution. Now, in truth, if you got to the correct solution and provided everything, and then an individual wasn't exposed to silica, it would not matter that you had not done a proper risk assessment. But the chances of actually complying and providing the correct PPE and taking all the correct measures is quite low if a risk assessment hasn't been done. It would be purely by guesswork or by luck. So it is the first thing I would expect to see, and clearly I would hope to see if I was asked to do a defence or indeed go to trial on one of these cases. And perhaps one thing I should just touch upon, I didn't mention in the breach of duty element. It's often that individuals will have worked at more than one employer or for more than one defendant. So there may be a series of exposures, and generally in this kind of a case, you'd consider all the exposure would contribute to the overall condition. So it may be that if you were someone who, or acting for an employer, a defendant who was using silica, it may be that just by showing some of these features, the risk assessment, PPE, etc., you can show that although everyone else might have been in breach, you were not in breach. So you may be able to avoid it, even if the individual has got silicosis, and even if 2, 3, 4 other employers, defendants have been in breach of duty. You may be able to show by the documentation and what we're going through now that you were not, and that of course is the important feature, that you haven't contributed to the injury. So next slide, please. So what the risk assessment should do is you should then, at the end of it, know the level of exposure, or if not, the risk assessment should be line one, work out what the level of exposure is. Of course, that will be different for different individuals, maybe working in different parts of a premises. It may vary from time to time. There may be some materials that don't include any silica, some that have small amounts, and some that have very large amounts of silica. So different testing will be required at different times depending on what is being done. Also, depending on what you are doing to it, whether it is heavy grinding or light grinding or polishing, will all create different levels of RCS at different times. So measures that may be undertaken. Talk about engineering solutions. That in some ways, some of those can be quite complicated. Can be getting equipment that is less likely to or has a system for keeping the RCS and rather than putting it into the atmosphere. It can be simple measures such as a curtain or a screen, so that perhaps a person who is using it is exposed, but it doesn't go beyond that immediate area. Ventilation systems are a key one. You'll expect ventilation, so that if there is any silica RCS which is produced, ideally it just disappears out of the premises and not into the premises generally. Personal protective equipment, of course, sometimes considered last resort, but probably likely to be worn, and make sure it is, of course, the correct type and it is worn correctly. Trying to reduce the number of employees that can be, for example, the screening system. If someone is cutting something using silica, if there is a screen up or some sort of barrier, not everyone else is exposed to it. There needs to be a method of enforcement. I touched on the health surveillance and information instruction and training. So what the risk assessment is, it will look at all those features and say we are going to protect someone from the risks of silica, not getting silicosis, by the combination of those which is suitable for our particular premises, and everyone's risk assessment will be slightly different. Next, please. So touching on that, what I would like to see if I was drafting a defence or if I was in court, I would look for a risk assessment. We talked about the monitoring of exposure. I would look for some record of measures taken after the risk assessment, or alternatively, really a risk assessment that is developed over time. So one that may, for example, be done every year. It is also the case that should there be a significant change in what is being done on the premises, a risk assessment should be redone, or in whole or in part, just to take into the fact that the processes might have changed. For example, if you are using materials which are now containing a lot more silica, then of course a risk assessment will need to be revisited because of that. A lot of this is about evidencing what is happening, and it may be, as Nicola said, that it may be that these things don't happen immediately. It may be that you're asked about this 5-10 years time when someone's silicosis has developed, and the difficulty with that, of course, is people's recollection and maintaining documents. The cases which are easiest to defend are those where there is a very long history of documentation, where risk assessments have been undertaken every year, and you can show what's happened from year to year. You can show the measures that are undertaken. So part of it is keeping and maintaining that documentation. First of all, it being right in the first place, but secondly, then keeping it and maintaining it and updating it. Likewise, with something like a PPE policy, personal protective equipment policy, it needs to be quite specific. Again, ideally, it set out exactly what is required in which areas and what tasks. It may not be required at all stages for everyone. In fact, wearing respiratory protective equipment all the time is something which is actually quite difficult to maintain for individuals. So it can be done at certain times, doing certain tasks. You need to set out how the individuals are trained on the equipment and when to wear it. How it's enforced, me and Nicola must have seen more cases than we care to mention, where there's a perfect document saying exactly what should have happened, and you ask anyone on the shop floor, did it happen? And everyone shakes their head and says, no, I never bothered enforcing that. So there is necessity to enforce it. How it's provided is another thing that sometimes is put into dispute. And an employer will say, look, we had loads of PPE, and the claimants will say, look, I couldn't find it, and whenever I asked for it, I was told we wasn't allowed it, or it's locked in a cupboard, it was only opened on every third Thursday or something like that. So there needs to be a clear easy way of people being provided with PPE. Ideally, all of that would have been signed for. So sign that the individuals have trained on the PPE policy, sign they know that there is a enforcement, and if they don't wear the PPE, as there may be disciplinary measures taken. They sign first of all to be provided with PPE, and sign to know that they know they can get it replaced, for example, in an open cupboard where the PPE store is, or whatever it is. This, of course, needs to be repeated over time as well. So it's not just good doing it on someone's induction, it should be done throughout someone's employment. Health surveillance, again, it will depend on the level of exposure, whether the level of health surveillance necessary, but it is something that should be undertaken if someone is exposed to high levels of silica on a regular basis, or indeed any level of silica really. Health surveillance should be set out a policy and indeed implemented. Again, sometimes we see policies without any implementation, which is no good. A key feature of all of this is information, instruction and training. It should start off at the induction. It should be set out who did the induction, what was covered on the induction, and simply saying PPE and health and safety, which again, me and Nicola no doubt will have seen 100 times. That can mean anything. That can mean hearing protection. It can mean anything. What does it mean? Was someone told about the PPE policy? Was someone told exactly about where to get their PPE? That should be set out in the induction. And it's pretty easy. All you need is a table and an entry for a date, someone's ticket and a signature box, and you can go through all of that, and it's relatively straightforward. And then from day one, someone has, or around day one, someone has this. Likewise, in relation to training, it's not something that's done once and then forgotten about. It should ideally be done on a regular basis, formal sessions as necessary, toolbox talks, so informal talks. Again, just doing them is not that helpful because people's memory fades as to how often they are done. Often you'll see defendants say, "Oh, we had regular toolbox talks," and the claimant saying, "Well, it happened once every blue moon." Again, if this is evidenced by someone signing toolbox talk chat, and it needs to be a 15-minute chat about PPE, for example, everyone signs it, it's put in a drawer, and then that's there. Now, ventilation is another area where documentation is important. First of all, documentation that it's been installed, not that you just got some ventilation. That's not going to be good enough. It has to be something which is tested, knowing the forms of exposure, levels of exposure, that someone suitable tells you that this is a suitable ventilation system. It is then regularly maintained at whatever maintenance regime is suggested. And again, the number of times I've heard people say, "Oh yes, there was ventilation, but it was, I don't know, like an asthmatic ant, blowing something around. It was not going to stop any silica coming onto me, and it used to break down all the time, and nothing happened." So again, evidencing all this, because this may be happening 5, 6, 7 times. 5, 6, 7, 10, 15 years down the line, and the corporate memory will have been forgotten by that stage. Next slide, please. Touching on that, the typical complaint, or the thing, as I've mentioned there, and me and Nicola will have seen more times than we care to admit, there was a risk assessment, but I never saw it. I never signed for it. There was a PPE policy, but no one ever enforced it. The managers used to walk around without any PPE on. So it is about evidencing it. It's much like, I don't know, medical negligence case where you have to have medical records showing what's happened. It's exactly the same as that. You want the documents to say, look, this is what it is, and this is how it is enforced. So from my perspective, I would feel fairly confident if I've got that kind of evidence against a claimant's recollection of what happened. In the alternative, if you have no documentation, the claimant turns up with 2 or 3 other people and said, look, this PPE policy wasn't worth the paper it was written on, or indeed it was not written on because it was not written down anywhere. So very much documentation is king in these kind of cases. Next slide, please. Right, that's the end of our chat, Nicola.
Yes, thank you for that, Jim. Just to touch on the ventilation point, I've been dealing with an asthma case recently where they said there was adequate ventilation because somebody left a window open. So there is a lot of cases where ventilation's got to be extraction and the proper things of it. So that there is that to look out for
I
sure.
had a similar one where they said it was ventilation, it because the window, the doors were open, which actually
Mm,
might have been fine, apart from the doors were always closed in the winter because it was cold, too cold.
exactly the
So,
same in mine. So it's something to look out for definitely when you're dealing
yeah,
with
it
these
needs to
sorts
be
of
done properly.
cases.
Yeah, yeah.
Absolutely. Does anybody have any questions for us? Just to confirm, the recording of the webinar will be sent out and the slides will be sent out. So if that does raise any questions that you want to ask, our contact details will be on there to chat further. But does anybody have any questions for us now? You can pop those in the chat box if you do. Give it another minute or so. Appreciate there's quite a lot of information to digest there. But hopefully everybody's found that interesting and informative. It's certainly been lovely to work with you, Jim, on this and to
Yeah,
present it.
I've enjoyed it. It's always good. I find you have a different experience of cases than I have. Just because I've seen different cases. So it's interesting to compare notes and see how these approach differently. But they can be quite complicated cases, and often over anything involving a long period of time. As we touched on towards the end, it's the evidence is a key thing and being able to prove that you have a good system rather than just saying you had a good system.
Absolutely. Well, it doesn't look like, oh, no, it doesn't look like we've got any questions there. So thank you everybody for attending. As I say, the recording will be sent out, the slides will be sent out to you. If there are any cases that you wish to discuss, Jim and I would be very, very happy to chat those through with you. So please do get in touch. You'll have all of our contact details on there. And thank you very much for so many of you for joining. We hope you've enjoyed it and it's been informative. So thank
Thank
you
you very
very
much,
much and have
everyone.
a lovely
Yeah.
day. Thank you.